There's an expression which says, "May you live in interesting times." This appears to be loosely based on an old Chinese curse, "May you live in an interesting age," which seems to wish that the recipient of the curse lives in a period of uncertainty and insecurity. I don't think anybody can doubt that we live in a period of insecurity and uncertainty following the events of last week. Change is most certainly in the air. So this week and for the next few weeks, I'm going to be speaking about transitions. And this week I want to speak about the transfer of a going concern. This can actually occur in various situations, but most commonly it is where a business changes ownership. The transfer of a going concern therefore includes the sale of a business or a part of a business, including its assets, and subject to certain conditions. The sale is treated in law as neither a supply of goods or services. In this situation, you cannot actually charge VAT on any of the items transferred. As I mentioned before, the most common situation where you come across a transfer of a going concern for VAT purposes is in the sale of a business, but there are examples up on the screen now of other situations where it can also apply, including the cessation of the previous trade or the death or retirement of the previous owner. In determining if the rules apply, there are two fundamental tests. The first is that it is actually the transfer of a going concern, that the part being transferred is capable of separate operation, and it has to meet certain conditions. Firstly, the assets being transferred must be part of the transfer of a business as a going concern. Secondly, those assets must be used by the purchaser with the intention of carrying on the same kind of business as the seller, although it does not need to be identical. The purchaser must be or become VAT registered, and if only part of a business is being sold, it must be capable of separate operation. The transfer must be in anticipation of the purchaser carrying on a similar trade, and so if there is an immediate forward sale of the business, this will thwart the transfer of going concern rules. There are a number of complications concerning transfers of land, but we will not go into these in detail today. But I will flag up the fact that if there is an option to tax, then the purchaser must opt in their own right and notify HMRC and the seller, but this is likely to have been a condition of the sale contract. Now, if HMRC take a closer look at the transaction, there are a number of questions you can expect. What did you think you were buying? Does the contract have restrictive covenants? Has a tax invoice been issued? Have your customer lists and suppliers contracts been transferred? And are you carrying on the same kind of business? There are a lot more questions than these listed in the HMRC manuals, but I've just picked out a few. Another couple include, were the assets transferred sufficient for the purchaser to carry on the business? And if part of the business is being sold, is it capable of separate operation? HMRC themselves have identified a number of areas of difficulty. Firstly, the rules will apply where the assets of a business are acquired piecemeal, where finance is not available to buy the whole thing at once. If the seller mistakenly shows VAT on a sales invoice, this is not legally VAT and therefore the purchaser cannot reclaim it. If they do, then HMRC may well ask for the input tax back, and then the purchaser only has recourse to the seller. In any transaction, there are liable to be professional fees which will carry VAT, and there will be situations where the input VAT has to be restricted. If the part of a business that's being transferred is actually exempt from VAT, then the purchaser cannot register for VAT and the TOGC rules will not apply, and the seller must charge VAT on the equipment. As previously mentioned, where there are successive transfers, the TOGC rules will not apply. Finally, there is the question of access to records of the seller. If the VAT number is being transferred to the purchaser, then the records must be transferred as well. But otherwise, the seller must just give access so that the purchaser can comply with its legal obligations. This is a very complex area of VAT law. If you're in this situation, I would recommend that you contact us without delay to avoid some costly pitfalls and a lot of stress and legal fees. I'm Alan Long from the Long Partnership, making life less taxing.